Do you know
I
what
don't know.
mean?
What we just like, I just really enjoy when people are ball busters. So it's just an extension of that.
Exactly. And
Yeah, my daughter is on a pop song.
that's so
like,
cute.
really? I didn't know that.
she's
Oh my
like,
gosh,
I told
she's
you
so much
I
better
wanted to
than
be a
me.
pop star, and like now my child has like superseded all of my life dreams
That's fantastic.
at 3.
But they
How did
know.
it?
I don't even know how people found out. Mostly probably because I was on the internet. Like that's my daughter. That's my daughter. No, I didn't
You
do
going
that.
to be.
Hi, besties. It's Katie from Without a Crystal Ball. Welcome back to my channel. You know what Blake Lively's attorneys are currently doing in court? They're pretending like they haven't subpoenaed 107 content creators, and they are pretending that there hasn't been multiple letters filed by content creators seeking sanctions or demands for protective orders against Blake Lively. And Lively has subpoenaed, according to Ellen Garofalo, who represents Wayfair, 107 creators, many of whom have not filed anything on the docket. I, for instance, did not need to file anything on the docket. Why? Because right as I was preparing to file a motion to quash, Miss Lively decided that she was going to withdraw her subpoena against me. My attorney spent more than 2 weeks working. We had a motion to quash drafted. We had my declaration drafted. We had been going back and forth with her attorneys for weeks, trying to get them to drop it. And it was only after they started hitting the docket that she started withdrawing subpoenas. And many of the impacted content creators are writing letters to the judge. And I've debated myself just writing a letter on my own behalf, not even asking my attorneys with the same arguments as these creators. And I don't know if I will, but I understand why people are doing it, because what we all went through for those couple weeks, and some are still going through, put so much stress on us, and financial stress and emotional stress, and took away our time from our jobs, that she simply just withdrawing it afterwards and then just saying no is allowing her to avoid any accountability in the court. There was a document filed by Mackenzie Folks, and she was the one that has the small channel that wasn't monetized, not even 1,000 followers on it at the time that Blake subpoenaed it. I mean, 2 subscribers. And she writes, while the plaintiff has now withdrawn the subpoena, movement respectfully asks this court to review the motions to quash and its accompanying evidence in full. The contents of the motions demonstrate not only that the subpoena lacked the legal and factual merit, but that it was issued as a part of a broader pattern of harassment, intimidation, and abuse of process. This withdrawal should not shield the plaintiff from scrutiny or judicial oversight. To the contrary, the motion to quash now serves as an important documentation of how subpoena power was misused against a private citizen engaged in protected speech. Movement urges the court to take judicial notice of this pattern of conduct of the plaintiff. Movement respectfully urges the court to impose the most severe sanctions permissible under the law in light of the plaintiff's abuse of subpoena power. This conduct reflects not only a disregard for the rules of civil procedure, but intentional weaponization of the legal system to harass, intimidate, and silence protected speech. Such misuse of judicial authority by a high-profile litigant against a private individual threatens the integrity of this court and the fairness of the proceedings. Movement therefore asks the court in its full discretion to sanction the plaintiff to the maximum extent allowed under Rule 45, to send a clear message that this kind of conduct will not be tolerated. So what these content creators are doing, Mackenzie, Cassidy, Lauren, Ashley, is they are all looking at Rule 45, which is the rules that are set up for subpoenas and what you can and can't do in terms of issuing subpoenas, and whether or not you're issuing them for harassment And harassment is a form of undue burden, and courts take it seriously. So, what they're trying to tell the court throughout these filings is that she is repeatedly filing overly broad requests to numerous people, that she's got a pattern of issuing numerous or excessive sweeping subpoenas. And it's aimed not at helping her case, but rather disrupting the business or personal life or trying to chill the speech of the people that she's targeting. They're telling the court she doesn't have a proper motive, that she was malicious. She's doing this to, embarrass. They're not being done in good faith. And that they're looking at the overall pattern of how she's been issuing these subpoenas broadly to so many different people. Okay. And I would think that, 107 subpoenas should raise flags for a judge, which could be why he's considering a protective order against Blake. But when Cassidy filed her objections, she is also referencing Rule 45. And she says that what she did was bulk subpoenas instead of targeting individual people. So she said there's 43 separate and distinct individuals were not served separately, but from one sort of bulk subpoena, as if the court were a Costco. This wholesale warehouse style subpoena is even more shocking because it was served on at least 3 separate and distinct social media platforms and was not served all at once, but rather over the course of several weeks with different requests for each platform. And by serving a single subpoena across different platforms and targeting dozens of unnamed individuals, the issuing party bypassed both the letter and spirit of procedural rules. Because generally speaking, subpoenas are supposed to be used for a single individual. And she's arguing that the subpoenas were procedurally defective, issued in bad faith, and in a clear abuse of process. And it was used as an attempt to harass, intimidate, and unmask anonymous speakers without court approval or showing of relevancy or necessity. She called out Blake and her attorneys for withdrawing it after motions were quashed were filed because they knew the subpoenas were meritless. She takes issue with that the court is saying that these motions to quash are moot now. And she writes, should the court indulge this request, it would be an excellent strategy indeed, for not only would it spare her judicial review of our motions to quash, but as a denial of our motions, it would also appear on the court record as a ruling in her favor. More importantly, it leaves her legally questionable subpoena intact to continue to wreak havoc on other content creators already named by it and additional CCs. Miss Lively intends to use this buy one, get 59 free subpoena that she informed the court she needed to extend the discovery schedule in order to continue plucking names to reuse it on, seemingly at whim with no evidence or proper procedure behind it. In another strategic move, Miss Lively counsel brings to her letter mentions of Mr. Fritz's latest filing with no relevance to Movement's situation whatsoever. Movement was not subpoenaed because of Mr. Fritz or anyone related to Wayfair. Miss Lively to date has failed to inform the receivers or the court on what legal basis Movement and the other receivers' names were chosen to receive this questionable subpoena. She was caught in her lies to the public and to his honor when she reacted to docket 444 and 445 by stating that our names were chosen to be subpoenaed by Miss Lively because we were on a list provided by TAG in their interrogatories, and that the criticisms were brought to Miss Lively because of the subpoena were unfair and of Wayfair's doing. She lied again, stating that because of Wayfair's counsel keeping the list improperly designated as AEO, Miss Lively was being unfairly targeted and could not produce the list to defend her erroneous subpoena. On the contrary, Miss Lively's claims made us a target because her claims were believed by her supporters, who quickly targeted us, repeatedly quoting these lies and putting blemishes on our reputations. We were unable to defend ourselves against these lies. The people put faith in legal documents filed in this court, and as the public should be able to do. In this case, it was us, not the court's docket, that held the truth. And had Wayfair not voluntarily stepped forward and stripped her AEO designations and revealed the list to the public, our reputations would still be in question. These circumstances make the second paragraph image found on page 1 of docket 496 especially distasteful, as after such treatment, she continues to try to put forth accusations on the very document meant to release us from the subpoena. Then she calls them out for lying about why they were withdrawn, and really just, oh my gosh, she goes over all these different lies, so many lies. So here's what she wrote. In her continued lies to the public and his honor, she begins a sentence with, based on the third party's representations made in meet and confers, leading you all to believe that she met and conferred with us. She did not. Although attempts were made to do so, Ms. Hudson informed those she intended to meet with that there would be upwards of 4 attorneys included in a Zoom call. Outrageous, as none of these receivers were legally represented, and that they would not be allowed to record the meeting in any way or have anyone else present for it. None of the receivers felt safe to speak with her under those conditions. The intimidation was keenly felt. Ms. Hudson's misrepresentation to the public and his honors continues when she states there is no further information required from the subpoenas as to these specific third parties at this time. Making this statement after the statement that she had met and conferred with us leaves the implication that she has in fact received information from these imaginary meet and confers, as she deceptively uses the words no further information. It cannot be denied that in order for there to be further information, some information had to have been provided. Since these meet and confers did not take place, this simply could not have happened and did not happen. Now, I did have a meet and confer with them, or at least my attorneys did, and some of them did, but it sounds like what's happening here is that the content creators that appeared pro se without attorneys were uncomfortable meeting with Ezra and the team alone because they were making everything on their terms and their terms alone, and then not allowing them to have their own representation or an advocate for them while they met with these attorneys, which truly is so intimidating if you are someone that has never dealt with legal matters at all, and you're someone that, isn't capable of hiring attorneys like Ezra, who probably charges $2,000 an hour, right? And then you've got 4 of them in a room with you. Page 2 of the docket 496 does not get any better, as it continues to imply there's a link between us and Wayfair in this mythological smear campaign when she states, Miss Lively's subpoenas were one part of the discovery process, and at gathering information to link the Wayfair party's activities to sources through YouTube and X content creator accounts, which is an extraordinary claim since there is absolutely no link between our channels and the Wayfair parties. Instead of these insinuations, it would have been much more helpful for her to have supplied the court with the slightest hint as to why the names on the bulk subpoenas were chosen, or even the tiniest drop of the legal reasoning behind it. The lie is repeated that Miss Lively's counsel has met and conferred with various individuals whose account information is the subject of the subpoenas, including the third parties who have filed motions to quash, when she well knows that these meet and confers did not take place, and asks the court to deny them as moot, something we object to for the reason stated herein. In her footnote, she mentions movements asking the court to revoke the subpoena as a whole, not just for movement, but for all involved state case law, informing that the court movement does not have the power to request that on behalf of anyone else. However, the reasons movement has stated